Last month, we saw what may be the largest ransomware cyber attack in history, and businesses all over the world are scrambling to figure out how to protect themselves. But those entities that are regulated in the United States may actually face another risk that can be even more expensive than those ransomware payments to the cyber attackers. And that is the risk of an enforcement action from the regulatory agency that regulates them. Recently, U.S. regulatory agencies have been ramping up their enforcement activities in the area of cybersecurity. So today I'm going to talk about two different types of enforcement actions that we've seen from banking regulators and from securities regulators, and discuss what businesses should do now to minimize their risk of facing a cybersecurity enforcement action from a U.S. regulator. The most likely type of cybersecurity enforcement action is for failure to have an adequate cybersecurity program. And these can arise in several ways. The most likely way that we're likely to see it arise is for failure to prevent an actual breach. We saw this, for example, in May of this year, when the New York Department of Financial Services imposed a $1.8 million penalty on First Unum Life Insurance. Second, you can have an enforcement action based on the failure to report a cyber event. And this happened, for example, this March, when the New York Department of Financial Services imposed a penalty of $1.5 million on residential mortgage services. And finally, it's important to keep in mind that there can be a penalty imposed even when there is no breach at all. This is most likely to arise during the examination process, when examiners are on site and notice that there's a fundamental inadequacy or failure within a company's cybersecurity program. Businesses such as publicly traded companies, which are subject to public reporting requirements, face an additional potential category of enforcement action. And we saw this just last month when the SEC settled claims that it brought against First American Financial Corporation that related to the filing of a Form 8K after the company was on notice of a potential cyber vulnerability. And that settled for $487,000. But the violation does not have to actually involve a failure to report some type of cybersecurity failing. And in fact, in the case against First American, the basis of the charge was not the failure to actually report the cybersecurity vulnerability. It was the failure to notify the executives of the company about the existence of that cybersecurity vulnerability before the filing occurred. What that means is that potentially an enforcement action could be brought for failing to have those internal controls that would enable people to quickly report to management the existence of a vulnerability, even if there were no cybersecurity vulnerability within the company itself. There are several things that a regulated business should do to minimize the risk of a cybersecurity enforcement action. First, it's important to ensure that any statements that are made to regulators, in particular any required certifications, such as the New York Department of Financial Services annual certification, are actually true. Second, you want to make sure that you have documented internal cybersecurity reporting procedures and procedures for responding to those reports. In addition, you want to make sure that you follow those procedures. As somebody that regularly represents businesses both in drafting policies and procedures and in ensuring that those were complied with, it's surprising how often a business will have a great written policy, great written procedure, but they end up not following it because the people who actually would need to follow it aren't fully informed of the nature of the policy and procedure. In addition, there are a number of deadlines to keep in mind. It's important, first of all, to report the cyber event when required within the time limit that's imposed by a regulator. So for example, for the New York Department of Financial Services, that's 72 hours. You also want to make sure that you report, when required, the cybersecurity event to state attorneys general where the consumers are located. And different states have different requirements for that reporting. In addition, if necessary, you want to make a public disclosure about the nature of the cybersecurity event. And at any event, you want to ensure that before any public statements are made or public filings are made, that management is aware of the cybersecurity event so they can make a well-informed decision. After a cyber event, the executives are often going to be very distracted. So it's important within 24 hours to get legal counsel involved to ensure that all of the necessary reporting requirements are complied with. And good news, I'm a lawyer. So if you're in a situation where you need counsel about reporting a cybersecurity event, or you want to ensure that you have the adequate policies and procedures in place to minimize the risk of an enforcement action, give me a call. I'd be happy to talk to you.